We would like to welcome all viewers of this little seminar, which deals with the legal issues of the 28th Annual Vis Moot. My name is Andre Janssen. I'm a chair professor for European private law at Radboud University. And that is my colleague, my esteemed colleague, Dr. Pietro Ortolani. He's assistant professor also at Radboud University, and we both are today's hosts. Well, the idea of this seminar is actually not to provide a solution to the problem of the 28th Annual Vis Moot, or even to spoil the fun of the many wonderful teams of students that will participate in the event. Rather, we would like to use the problem as a springboard, as a point of departure for an open-ended discussion on the legal issues raised by the moot problem. For the purpose of this seminar, we invited two very esteemed experts in the field of international commercial law and international arbitration. Our first guest is Petra Butler. She is a professor at Victoria University of Wellington. She specializes in domestic and international human rights, public and private comparative law, and international commercial law, with an emphasis on international commercial contracts and international dispute resolution. She has published extensively in those areas. Petra is furthermore a fully qualified German and New Zealand lawyer, and she is admitted as a barrister to the High Court of New Zealand and regularly advises private and public clients in the area of expertise.
Our second guest is David Holloway. David is a barrister and arbitrator practicing from Outer Temple Chamber, London and Dubai. He has over 20 years of experience of practice in the areas of international trade and international arbitration. And he is also a senior lecturer in law at the University of Birmingham, where he is program director of the LLM in international commercial law at the university's new Dubai campus. David has previously held academic appointments in the UK, China, and Hong Kong, and has coached several successful Vis Moot teams in the past. So welcome, everybody. Andre, do you want to kickstart the discussion?
Yes. So our idea is that, we prepared two questions for each invitee. And also the second invitee can then comment on the question or on the answer if he or she wants. So the first question goes to Petra. Petra, it is not uncommon for a commercial contract to blur the boundaries between the sale of goods and other contractual types. Yet the legal qualification of a contract brings about, as you know, fundamental questions, especially in terms of the law applicable to it. What are, in your opinion, the key considerations that arbitrators or judges should keep in mind when determining what is the predominant nature of an international commercial contract? And is the wording of the CISG still adequate to deal with the current reality of international commercial relations, which more and more often also involved dematerialized digital assets?
Thank you, Andre and Petra. I'm delighted to be part of this little seminar. Well, let me just start with saying, and just to pointing out, which might be obvious, but I thought it's a good starting point, that the CISG, of course, lacks a precise definition of a sales contract, and that might be quite important to answer your second question you just posed. Nevertheless, the convention itself provides, of course, for an autonomous concept, which is derived especially from Article 30 and 53 of the CISG. According to these provisions, the sales contract obliges the seller to deliver goods, to hand over the necessary document, and to transfer property of the goods. And the buyer's obligations consist of payment of the price and taking delivery, and we're not so much concerned maybe with this at the moment. So to answer your questions, I want to go back and basically discuss or elaborate on two issues. The first one is what is a good. The second one, what is the demarcation between a sale of good and service contract. So what is a good? The convention does not define goods. And looking at Article 7, which we need to take into account, which says we need to do an autonomous definition, which is not supposed to be derived of domestic law, we take into account the international character of the CISG. So that gives us actually quite a wide and very flexible in certain way approach to the definition of a good. Now, it is probably generally, or it is generally accepted among scholars and courts that goods are at least movable and tangible items. And I will give some examples in a second, because that actually already gives us quite a surprising number of goods that can be traded under the CISG. Important and decisive is the time of delivery. To determine what a good is, the criterion which is probably the most important is whatever we think a good might be, or how we define it, it has to be suitable so that the rules of non-conformity can be applied. So what we can't use the autonomous interpretation for is to alter the characteristics of the convention, of the sales convention, to something else. So that is basically our limit. Let's talk about some examples what at least the literature discusses what a tangible object is. And that includes livestock, human organs, artificial limbs, cultural items, and pharmaceuticals. So these would all be considered goods under the CISJ. That seems to be in one sense easy because we can all touch that. More interesting, of course, are the things we can't so easily touch. And from very relatively early on, I think in the early 90s, end of the 80s, a big discussion was around software. I think the discussion has moved on in the way that it is today. We can say if software is permanently transferred to the other party in all respects, maybe except for some copyrights and restrictions to its use by third parties, but becoming part of the other party's property, as opposed to a mere agreement on temporary use against payment of royalties. The contract is a sales contract because the buyer is put in the same position as a buyer of a good would be. So the important question here is the recipient placed in a legal position that equals that of a buyer in accordance with Article 3? So taking from that is that apps and ebooks are without any problems goods. What are not goods, to do it negatively, are definitely rights. They are definitely not covered by the CISJ. There is also a demarcation question, what is between a good and a right, that again needs an autonomous interpretation under Article 7. But here, the idea is goods have to have some sort of physicality. And if we think about software, the physicality is a data storage medium. So it can be put somewhere which becomes tangible. Equally, Article 41 and Article 42 demonstrate the mere fact that items are subject to property or IP rights does not influence the character of good as a good. So that's also important to know. Another gray area similar to software might be know-how and academic achievements, results. And that might be quite controversial, but if you think about it, the same would apply. So if you somehow can make the know-how, the scientific results physical, as in instructions how to use something, then that would meet the definition of a good. And That's basically what we're looking for and can be owned as property. Coming to the second point is the demarcation between the sale of goods and services. Now, this comes a little bit more closer to your question you were asking me. Important to note here is that there was a Swiss proposal a few years back whose aim it was to establish a sibling convention to the CISG dealing with services. This proposal did not give enough backup at UNCITRAL. In Singapore at the time, which opposed the idea of that service convention, did so because at the time it was felt, as Singapore felt, a complete lack of appetite for the CISG already, and so saying, why do we need a service convention? Now you might ask, why is this relevant? It is relevant because one can read this in two ways. Firstly, as an invitation to interpret the CISG, as for example Article 3, widely to give the CISG more relevance. Or one could read it the opposite and narrowing the application because saying there is no appetite for a more unified approach to international commercial contracts, especially ones with a service element. If you look at this and look at Article 3 in light of this kind of comment, then we would say Article 3.1 is very clear. It talks about contribution. So this is Article 3 is about the demarcation between, just to repeat this, service contracts mainly and others and contracts where the buyer has to contribute significantly in a sales contract. Article 3.1 talks about the contribution of materials. In light, if we are CISG minded, we want the CISG to apply to as many contracts as possible. We of course say this only talks about, very literally, physical materials. So non-physical contributions do not fall under Article 3.1. Article 3.2 excludes contracts to the CISG if the predominant part of the obligation of the party who furnishes the goods consists in the supply of labor or other services. We want the CISG to apply to as many contracts as possible if you are CISG minded. And as a CISG community, of course, we are. That actually means that things like know-how or licenses would not be considered services or labor, because otherwise this would allow for the CISG not to apply. So actually a wide interpretation of the CISG means we exclude anything that would hinder the application of the CISG. So in summary to your questions, my key demarcation points are, firstly, and I didn't mention that because I thought it goes without saying, is party autonomy still trumps. And I think the CISG is flexible here. It allows for party autonomy. It allows for modification of provisions if the parties so wish. It gives a really good framework to work under and to modify from. So definitely, key point is always party autonomy. And parties are actually allowed to agree for the application of the CISG, even if normally the CISG would not apply to that contract. Secondly, a demarcation point for me is that a good has to be something that has some form of tangibility. It can be put on a host structure so that the rules of non-conformity have to be able to apply. And the demarcation to service contracts, I think the status quo, as discussed in the literature and in the jurisprudence under Article 3, is absolutely adequate and perfect and strikes the right balance. The CISG is very principled. Article 7 allows for gap filling, and actually Article 7, and that's what I alluded to at the beginning, also I think allows us to go with the time and where we see a change, and especially also a change in the in international trade, and also in the comparative sense, allows us for us to adapt the CISG. a classic example would be under COVID as the discussion around hardship in the CISG, for example. Thank you. That's it from me.
Okay. Petra, thank you very much for your answer. And David, would you like to?
Yeah, very, very briefly, I was interested in the question in the conflict of laws aspects of it. And I kind of totally agree with Petra that party autonomy should be the starting point. So it would seem very strange if the parties had chosen the CISG to govern their contract only to find that because the CISG defined it as not a sales contract, we have to look for other conflict of law rules to find the applicable law, or that the CISG was chosen by the parties, but by its own terms was not applicable to the subject matter of the contract. So I think that would be a strange scenario. The problem, I think commercial parties are often very, adept at defining the law which they want to govern the contract. And if the problems arise when they don't do so, and when we arrive at a choice of law by virtue of conflict of law rules, which point to the CISG, but may well point to the CISG only to the extent that the contract is defined as a sales contract under the CISG. And that can lead to problems where different aspects of the case can be governed by different laws potentially, and there can be opportunities for parties to tactically take these kind of points. I don't think there's much you can do to stop that in real life. I mean, one option is the CISG expands its application by virtue of broad interpretations of its terms. That's possible, and for Petra as a CISG enthusiast, desirable. But I guess you have to look at the bigger picture here. This is one aspect of law on which there is very successful harmonization, but perhaps if it overreaches itself, there would be a backlash against that. So just a few random thoughts there on the conflict of laws points.
Can I respond?
Sure. Please.
David, I agree. I mean, I think what I wanted to say, and this is why the definition of goods has its limits. It cannot be used, to expand to a phase where you alter a sales of goods convention to a service convention, for example. Yeah, that can't happen, and that would be against the entire intention of the member states as well. But I just want to pick up one point you said about the parties. It's a little bit of a hobby horse of mine, because I've done all this research around, all the qualitative empirical studies, and I think what I found is small and an unsophisticated party sounds always really bad, but I mean parties who don't have an in-house lawyer, who do not have access to lawyers for various myriad of reasons, yeah, and they're normally small and medium-sized, depending on which country you are in. And actually, for them, they don't think about disputes at all from the start. Yeah, that's not even on their horizon. That's not they build it on trust. And for them, actually, the CISG is the best thing whatever happens, because if they start thinking about the choice of law, yeah, we have one party. This is my favorite example, where in the choice of law clause, it said you basically was between Australia and Italy, and if the buyer who was in Italy had a problem with the good, it would be Italian law and the Italian courts. And if there was a purchase price payment problem for the seller, it would be Australian law in the Australian courts. Yeah. And that sounds incredibly logical, I think, if your common sense approach to a certain degree. But we all know that it's a nightmare. And for those kind of parties, I think the CISG is a godsend, because it puts everybody on a level playing field.
Well, thanks a lot. And if you all agree, I would like to move to the next question. Petra, intellectual property rights play an increasingly important role in global economy, and that even to the point that it is sometimes even impossible to detangle the economic value of a tangible asset from the intellectual property right that is connected to it. So this in turn raises some really interesting challenges for lawyers, I think. So in the context of a sale of goods contract, to what extent can we consider the goods to be non-conforming if a third party advances a claim that is based on intellectual property rights? Where do you draw the line? Please, Petra.
Right. So I hope I will ask this question in the way you want me to ask that. Well, first point again, party autonomy. Yeah. So starting point has to be again the contract and what the parties actually agreed on in the contract about the use. So because it will depend on the IP right. Yeah. So for example, the basic IP rights attaching to patents are make, use, and sell the invention, or more technically, the invention that embodies the invention as claimed as a patent specification. So as for line drawing, I would say consider express implied expectations accompanying the transfer of the goods. Yeah. So for example, the expectation of a quiet title to the goods. So if the goods embodying the patented invention cannot be used or sold without infringing the patent, it seems difficult to say that the purchaser has a quiet title. So again, it is really specific, context dependent on the contract and on what the parties actually agreed on. Yeah. So in other words, the decisive factor must be whether the third party right is of such a nature as to impair the contractually agreed use of the goods. Hard, sounds when you describe the picture very well how entangled it is, but you can untangle it by actually really going back to the contract and being really clear what the parties actually agreed on, also in regard to the use and what the expectations were in regard to the use of the right. It might also, of course, picking up a little bit on David's point before, it might also make for better contracts at one point, because if that point is coming through, you would hope that the parties put a little bit more effort, not effort, but put their minds to it, how to entangle this. The other line drawing issue is the question of how strong the third party claim has to be. Is a spurious claim enough? Would the patent survive a non-obvious challenge? And you can also ask us differently, does Article 42 of the CISG safeguards against the seller against patent trolls and trademark squatters? And the commentaries generally state that Article 42 is also applicable in case of unwarranted third-party claims. And I actually would draw a difference between unwarranted claims, meaning claims where the third party reasonably thinks they have a claim, and claims which are clearly spurious, so the trolls and the squatters. A seller will never be able to foresee those and cannot protect those. And the general principle in the CISG of good faith, and I know that that's also a little bit controversial, but I think we all can agree that there is at least a principle of reasonableness in the CISG as an underlying principle. In my view, commands that spurious claims do not fall under Article 42. And this would be, because that would be kind of allowing the creation of a CISG Italian torpedo. And that seems to be in line with the travaux préparatoires in regard to the seller liability generally of third-party claims. That it doesn't extend to frivolous claims. So there are safeguards also stated around IP rights for the seller, the liability for the seller is not limitless. Don't let us forget that. The liability only extends to the countries the seller is aware of the buyer wants to sell in. So perhaps maybe there aren't even any patents in the place where the goods are to be used or sold. That's always a possibility. And then there's also the question of what the seller and buyer have to be aware of and who needs to prove what. Now, there is a Dutch court ruling decision that, and I can't read that in the original, so Andre, you might have a comment to that. But according to commentary, that said that in Article 42, the buyer must prove that the seller knew or could not have been unaware of the intellectual property infringement. So there's definitely some safeguards which I think put quite a good framework around IP and third-party claims and the core of our seller-buyer relationship. In Article 42.2 says the buyer is not that the claim only can be, so the buyer only has a recourse if the buyer was not aware of the right at the time of contract conclusion. So these are the safeguards built into the CISG already, being kind of aware how complicated that area actually is. Two questions remain. Should the seller be presumed to know about potential third-party intellectual property claims if the third party's intellectual property rights are registered or created under the domestic law of the buyer's location or in the location where the buyer plans to resell the goods? And the same question, the same way around, should the buyer also be presumed to be aware and know about third-party claims? And I actually think that here in that case, New Zealand Muscles case, the decision under Article 35 might actually be quite helpful. And I'm aware that Article 35 is not Article 42. So I actually invite everybody to take a step back and think about what was the reasoning, what was behind that judgment. And in the end, the way I read New Zealand Muscles was who could reasonably had the better option to actually get the information. And if we think about that, even under the third-party claims is normally probably, and most likely the buyer, when it comes to his own country, to know about his patent laws, be able to access the necessary information about pending patent claims, applications, even maybe knows, what else has gone on regarding, third-party claims. The same is true for the countries the buyer might trade in on sell. So I think that is something where I would say that needs a little bit more entangling and thinking of, but we have, consistency also among CISG decisions and actually the reasoning, the real reason behind it. The other thing I would say when it comes to IP rights is it's a little bit of a warning, and I'm not an IP lawyer, but I have a real issue with silo thinking. And of course, we have lots of international conventions, like the Berne Convention, for example, that actually regulate IP rights. And what can't happen is, whatever we do is, the CISG and the specific IP convention need to go hand in hand. We cannot have a regime in the CISG, which is in one sense not compatible with or against certain major ideas which were behind the IP convention. So it's not about the fragmentation of international law. It's about bringing international law together and making it consistent. And I hope that kind of answered or gave you some insight in what my thinking is around your question.
Petra, absolutely. So absolutely. Thanks a lot for your insights. I don't know. David?
Yeah, I will chip something in. I mean, I totally agree. And I the New Zealand Muscles case, I'm glad I'm not coaching the Vis Moot again, because I think I've had enough of that case. But it's quite correct that kind of thinking is applicable here. When I read the problem, and it's not that long ago, I mean, it seemed perfectly logical that, a sale is a transfer of title in goods. If someone else has rights over that, you haven't done your job in transferring it. But this language of any claim or a claim is problematic. That needs to be interpreted. Obviously, it cannot mean every claim, or we will have to, that the Italian torpedo was invented for patent claims, wasn't it? And that would be sort of imported into sales law en masse if it were any claim. But Petra's correct. I mean, the CISG is a classic example of a legal instrument that has the sort of general principles built in that enables people to take a sensible view on that. But it is a question that probably, at what point does a claim become a spurious claim? And at what point do the buyer and seller have to wait to determine whether such a claim is a spurious claim or not? Because there are obviously spurious claims and there are obviously not non-spurious claims. There's also a big grey area in the middle where, until you've actually delved into that dispute, you don't know whether it's a spurious claim or a founded claim. And that, I think, is quite an interesting point in this year's moot, because at what point do we have to delve into the merits of that third-party claim before we can decide whether to join those proceedings together or not? So it's quite nicely connected. I also really agree with Petra's point about the IP convention, that's very much something that Vis Moot teams should be doing, that high-level thinking and not just analysing this provision of the CISG, but looking at how it fits together with that wider picture. I think teams would be well advised to delve into that in order to add value to their briefs.
Well, thanks a lot, David, for your additional comments. And I think we could go on for hours, but now I would like to give the floor to Pietro, who is the second host, and then to David. Thanks a lot again, Petra.
You're welcome.
Sure. Yeah, so thanks to both of you. And let's jump into the arbitration side of things. I would like to ask the first question to David about the involvement of third parties in international arbitration, because that really has been one of the most noticeable changes that international dispute settlement has over the past 20 years. Traditionally, arbitration was a closed procedure, and the common sense was, well, you cannot add a third-party non-signature. It's just rule. But the recent practice of international tribunals and also the reform of many sets of arbitration rules actually challenge the traditional assumption, and they have progressively broadened the boundaries of arbitration, if you will, allowing certain very important categories of third parties to be joined in the arbitral proceedings. But this, of course, also comes as a consequence of the increasing level of interconnectedness of international contracts in supply chains. And it creates some challenges for us, of course. And the Vis Moot problem, I think, goes to the core of that. So, David, my question for you is, to what extent should a tribunal rely on the joinder-related provisions of a set of arbitration rules to force the joinder of a third party when the third party and at least one of the original disputants do not agree, raise objections against this joinder? And to what extent, more generally, such provision in a set of arbitration rules can override this general, more traditional principle that ultimately arbitration remains a...
Yes, it's a very interesting hot topic, as you say. Just going back to first principles, I guess, if you like, this is almost part of a sort of increasing battleground between arbitration and litigation, and litigation has always sort of had the edge here, because within their own territories and within the constraints of their own jurisdiction, courts can pretty much exercise discretion to join parties and consolidate proceedings. And there are incredible efficiency savings by being able to do that. I think the last question you ask is probably the most important one. Can this override the principle of party consent? Well, in my view, it just cannot. I mean, as a starting point, it may well be very efficient to get everybody in a room and have one decision, avoiding conflicting decisions, etc. But if parties have not agreed to arbitrate, it just cannot happen or should not happen, and there would be serious consequences if a court did take that, or sorry, an arbitral tribunal did take that extra step. The institutions have obviously all wrestled with this with a view to making complex and multi-party disputes more efficient, and they're all wrestling with that underlying problem of party consent. And it's something that, party consent has to be broken down into different components. If you ask many parties after a dispute has arisen, they may well not wish to arbitrate or may not wish to arbitrate in a certain way with certain people. So the idea that we all have to agree after the event is going to be difficult and impossible. If a party has actually agreed to arbitration, then the door is open, in my opinion, to a lot of procedural discretion for the tribunal. But then there are the questions of which rules have been agreed. So if you have agreed to ICC rules, HKIAC rules, LCIA rules, they all permit this joinder and consolidation under certain conditions. There will be problems if parties have agreed to different rule systems, or if one party has agreed an ad hoc arbitration and the other under the rules. And that's one of the problems that this moot problem is wrestling with. The rule systems have all adopted slightly different approaches. So if one looks, for example, at the HKIAC rules 2018, they make it pretty clear that this can only happen if the parties have all agreed to the HKIAC rules. So by everyone signing up to that process, they do impliedly agree to the process of consolidation or joinder. An alternative is that the parties can agree, even though they're outside that rule system, to join in. I think that's a pretty effective solution. The LCIA rules require party consent for this joinder and consolidation, which makes it more difficult after the event or in the light of a dispute, because there may be different tactical reasons why a party will not want an efficient process. And then the problem we have with this scenario in the moot problem is that we have an open-ended provision in the rules, which seems to not impose criteria such as that the rules must be the same or that the parties agree. Now, that is difficult, and that needs to be interpreted. So we're sort of somewhere between a requirement of consent, which the LCI rules have, or a requirement that everyone has to be party to the same rule system, which the HKIAC rules have. We're back to party autonomy here. I think it's not something that is absolutely precluded under the Swiss rules. It's not something that is limited. So we have to actually look at what the parties impliedly agreed to when they signed up to their respective arbitration agreements. And I think that means there is scope for the tribunal to exercise procedural discretion, and they will have to look at all the due process factors that are involved here, like equality of treatment in appointment of the arbitrators, like procedural efficiency, etc., etc. and that's a balancing exercise. I think what we also have to bear in mind is that there are consequences of not joining, and these can be quite severe. We can have asymmetric information. We can have parties tactically participating in parallel arbitrations. We can have one party having a lot more access to information than another party. We can have inequalities. For example, if one looks at the recent Holloway case on arbitral bias, we'll see what happens when there are multiple arbitrations proceeding separately out of the same incident, and there is sort of a common party with a common arbitrator with lots of knowledge of the surrounding disputes that other parties don't. So I think the rules here leave very much room for argument about firstly interpreting what the parties agreed, and then debating the procedural pros and cons of adopting either approach. And parties need to take quite a high level approach to looking at issues of procedural fairness, issues of confidentiality, issues of equality of treatment, and so on. I think this problem is probably insoluble in a broader way, because the question of party consent is there at the heart of things. And, you know, unless there is a more harmonized approach among the different institutions as to what is impliedly agreed when one agrees to an arbitration clause in terms of consolidation and joinder, then we will be arguing this quite a lot, I think, because there will always be tactical implications and procedural implications either way. Okay.
Thanks a lot, David. Yeah, indeed, I completely agree with you. The Swiss rules of all major sets of arbitration rules seem to be the gray area where the moot magic can really happen for the teams. Petra, would you like to chip in on this?
Well, a little bit. I have a little bit of a question, David. So, and since it's not only about the moot problem, I thought I'd bring up the 2009 moot problem, which also was about joining. Yeah, and in this particular case, I mean, it is always specific, and you discuss what about basically parties maybe on an equal footing. But it also becomes really interesting, and that was, you know, the scenario in the 2009 one was if you have a parent company behind, if that scenario of not wanting to join is one where, you know, you do it for tactical reason, and you have one party on the receiving end, yeah. So Dow Chemicals is a case which is behind that, and I thought maybe you could say a little bit about that as well, of what your view is around joining in that scenario.
Forgive me for not having the 2009 moot problem in top of mind, but I think, you know, when we're talking about party consent, there are certain rule systems that make this a precondition, and that, of course, if you've signed those rules, then that is understood. But in this scenario, when we're looking at an open-ended discretion on the face of it, I actually don't think whether parties consent to joinder after the event is actually really a very powerful factor at all, because there are all kinds of reasons why after a dispute has arisen, people may or may not want to join in the dispute. And some of them would be reasons which, you know, at heart would be unacceptable if we knew the real, you know, they obviously don't present the real reasons. But why do you know, parties will often, particularly parent substitutes, may often not want to do it just to be awkward, to make it difficult, to make it to make the outcome more uncertain to one of the litigating parties. So I think consent after the event, unless it's written into the rules, in my opinion, isn't such a strong justification. If there is agreement to arbitrate, if the rules do sort of give that discretion, then the idea that we don't want to, full stop, doesn't seem to me to be a powerful factor here. I don't know if that's, I can't remember. I was at the 2009 moot, but I can't remember whether that was part of it or not.
Yeah, no, thank you. That was just my thought on that.
Okay, then I would have a lot of follow-up questions, but in the interest of time, I suggest we move to the last point, which kind of breaks the fourth wall this year and brings in the digital revolution that COVID-19 has brought, not only in our everyday life, and this conversation of today is a perfect example of that, but of course also in international arbitration. So the conduct of online hearings, for example, which seemed to be science fiction maybe 3 years ago or 2 years ago, now has been dubbed by many practitioners and academics as a new normal in international arbitration. So, David, first of all, I would like to ask you a little bit about your practice. So what is your experience so far with online hearings? Have you been involved, for example, in evidentiary hearings? The conference, and in general, has your experience been positive with the use of technology in this new normal of COVID-19? And zooming out a little bit and involving the problem of the Vis Moot more directly, what do you think is the correct approach for a tribunal in this respect? Is it really reasonable for an arbitrator to order an online hearing, even if the parties fail to reach an agreement on this point, by way of example, by amending their original agreement to arbitrate, which provided for a physical hearing?
Yeah, I'll start with my experience. I've had quite a bit of experience of online hearings, going back like a 15-year period, and the first witness that we examined by video conference in an arbitration was about 15 years ago. I remember being very suspicious. We were all very suspicious about the other side's request to do this. And it turned out to be founded because, it could only be done this was in Houston. It was at the end of a very long day of hearing. We had to then travel for an hour and examine this guy who was in Singapore. And we were all exhausted and, we kind of felt this had been engineered. Secondly, we kind of realized that the witness was looking at some documents that we weren't sure what they were. So I remember asking if the tribunal picked up on it, and I asked if they could fax the document to Houston. There was a wonderful dramatic pause, and this page, it was a list of questions with suggested answers from the lawyer. It turned out to be completely harmless. I mean, it was, it could have been a lot worse, but the dramatic effect of that was quite something. And, so we were kind of vindicated that this was all a bit sort of sharp. On the other hand, we did actually detect what was going on. So it wasn't that easy for the person to do that. Now, recently, I've done quite a few hearings online, most of them not involving witnesses, to be honest, but even in court proceedings, now the courts that I've operated in the UK and the DIFC here in Dubai, they've been operating very successfully remotely for long periods of time, with judges in other parts of the world. Witnesses often, it may be one lawyer in the court, but 3 or 4 other lawyers and the judge on video. So it's debatable whether there is a hearing physically going on when most people, including the judge, are abroad. I'm a big fan of it, and I think that when one looks at the jurisprudence, I don't see any reason why there's an objection in principle to hearing witnesses by video conference. All the research suggests that it can be done as well, if not better, remotely than it can in person. The psychology, the courts in theory have recognized this years and years ago, but we are almost accidentally, I think, clinging on to this default option of all traveling and being in one place unless there's a reason not to. But I think we're now at the point where a remote hearing is just as much of an option as defaulting to a physical hearing. And we're probably moving to a future in which a physical collective hearing is going to be the exception rather than the norm. The cost savings on this, I think, are, one can debate about the cost of technology and so on, but I think it's pretty clear that this is going to be an enormous cost saving on travel and time. And I personally find it much easier to operate remotely in a comfortable environment, which I have designed myself, rather than having to schlep everything and worry if you've remembered all your books and online things. So there's that. Now, there are, of course, due process considerations that need to be taken into account. There are all kinds of issues relating to time zones. There are potential issues relating to access to technology. There are a number of things, but these could all be described, I think, as speed bumps that shouldn't prevent this happening, but should make it, make people take care in terms of whether to order a hearing like this or not. I mean, the underlying due process rules are there, and they apply equally to virtual hearings as physical hearings. But I don't see any of the arguments being advanced as problems. They are, if there is a circumstance where it would be manifestly unfair to one side to have a virtual hearing, then of course it should not happen. But tiredness of witnesses and time zones, that can happen in a physical hearing just as much as the other one. And one of the bugbears I have is some people saying, well, the witnesses should not be comfortable. They should be put in a stressful scenario so that they think very hard about what they're saying. And I just don't accept that. I think, the idea that a witness can only tell the truth if they're being harangued by someone physically, it doesn't work. I think people who are, in arbitration, who are relaxed and talking freely, are likely to tell the truth. Now, the issue in this moot problem, I think, is probably the thorniest one, because I think the one scenario in which the tribunal's discretion probably should be limited is if the parties have actually agreed not to have a virtual hearing. That is a very powerful reason not to have one. And I think in most circumstances, if that is the way the agreement would be interpreted, then there should not be a virtual hearing unless proceeding with a physical hearing would itself violate due process. And that would, could certainly have been argued by in many of the hundreds of arbitrations that migrated online during the COVID pandemic. It could well have been argued that if we don't do this, we're going to have to wait another year, etc. That may be an argument to get around an agreement for a physical hearing, but that's one of the few roadblocks, I think, is if the parties have just said we don't want to, then I think the tribunal needs, and I think that's the crux of this in this moot problem. I think to find a way around that agreement for a physical hearing, if such an agreement there was. And what else can I say about? Sorry, Petra, what was the last part of the question again?
No, indeed, the idea is whether to a certain extent it would be possible to force an amendment of the original agreement. I think in particular in cases where you could make the case that if you go ahead with the original wording written at a time when COVID didn't exist, the agreement risks becoming incapable of being performed. Yeah. There are certainly arguments that tribunals can modify arbitration agreements. Like one can think of, you have to look at this again, interpret this agreement in light of the wide discretion allowed in the rules and the guidance, the fact that physical hearings are not mandated by any of the laws and rules in force, as far as I'm aware.
And so, yeah, I'm not. I mean, there's a line. One can talk about interpreting this agreement. One can also talk about modifying it. But in terms of modifying it or overriding it, then of course that we're getting into very sort of tricky territory here. And I think one need to be, I think the arbitrators there are in a very invidious position, because I think they have to take the view that is it better to be attacked for going ahead and making an award here and taking the risk that it's going to be vulnerable, or are we going to get blamed more for delaying it? Now, that's the judgment of Alderman there. I'll leave it there for the minute, Pietro, because I'm sure Petra has equally quite some observations here.
Yeah, thanks a lot, David. Sorry, go ahead, Petra.
Sorry. I completely agree with you, and I think you beautifully pointed out the really thorny issue. I have a couple of comments, not necessarily related to the moot problem. Maxi Scherer wrote a very good article very early on the issues around, oral hearings, I think from memory she came to the conclusion if one party really objects then to an oral hearing, there's nothing you can do unless the lex arbitrator would let you. But I just wanted to pick up, go and point what you said. So in regard to costs of arbitration, I've been in another kind of arbitration forum where somebody said that there is, at least I think it was around London, the rumor it is actually more expensive now, the online hearings, than the physical ones, because it means that the partners actually have to be really prepared, because they can't wing it, in an online hearing, which they can in a physical hearing. Therefore, there are more hours, there's more hours of preparation, and therefore they're more expensive. So that it's kind of like a little funny anecdote on the side. The other thing I wanted to point out is, this is the next two comments with my human rights head on, is we need to be aware that there is, of course, a chance with online that certain people will be disadvantaged. And this is a tyranny of time zone, of course, and we can't forget this. And I can tell you, every single conference is for me between midnight and 5 o'clock in the morning, and you can do that one day, but you can't in a hearing. You can't do that 3 weeks in a row, and you probably can't even do that a week in a row. And there are time zones like, say, New Zealand, London, and then have North America, and it becomes nearly impossible. It has to be said, there is no good time. You find an hour or two a day, maybe, where it's good, green on the time zone converter for everybody. There's that issue, but there's also the issue, especially for developing countries, where still, there is no good connection, so the bandwidth isn't there, but also it is still so expensive that it puts them in a disadvantage too. To getting onto the internet. So that's definitely something to keep in mind in online hearing. And the discussion in Europe and North America has been a very European and North American discussion, where, of course, hardly anybody has bandwidth issues, and there's no issues around, access and maybe the money side, and time zones are still manageable. But it can get differently. And then the last one is, I completely agree with you when we're looking at can we force a party who doesn't want to do? I think the human rights answer to that is, it is about access to justice. And it is not always only access to justice, but it is specifically also access to effective justice. And this is a whole idea, justice delayed is justice denied. And I think, and there are, as you actually said, I just give you the human rights answer to it, basically. What you said is, if it puts the other party in a complete disadvantage, yes, I would have no problems to say the arbitral tribunal can demand from the other party to do it online.
Yeah, I agree, because any other option, just, we're back to this idea of having a veto, and, respondents, particularly, not always, will say, we've got this pandemic. I'd rather let's just wait and see for a couple of years and we'll have the arbitration later if it all dies down, rather than like we'll have it tomorrow. The cost issue is very interesting, actually, because we all assume that it is going to be cheaper by removing travel costs. There are startup costs to this, startup costs. I think the challenge is going to be institutions in, spreading that access and equalizing that access, because you're right, there will be certain parties who will be disadvantaged by this in the short term. And it will, I know we can argue that can all be taken into consideration, but if there is a club forming of people with this wonderful snazzy technology and you're not in that club, in fact, you're going to find yourself marginalized, because the default answer will be no, you have to do it this way. So we have to make sure that works. I do think the costs probably are, the cost savings are unarguable, and also the cost of technology is likely to decrease, what we would think, unless some evil monopoly companies get hold of it and charge huge amounts for it. But I think that's likely, hopefully, with goodwill to decrease over time, and access to justice to increase over time with this technology. I don't know. Do you agree with that, Petra, that the technology has potential to open up access to justice in this form?
Yes. Well, definitely. I think, as with all things in the world, for some and not for others. Yeah. So if I again think of my little SMEs, especially the ones in New Zealand, yeah, they just hate technology. Yeah. I mean, I think they would find what we're having now quite nice, but for example, anything online related is completely out of their comfort zone. So the step to get there is a huge one. If you talk to SMEs in Hong Kong, for example, completely different, kettle of fish. Yeah, they're probably far more technology affine. So it depends a little. But I think the only thing you can do here, and that I think is fair enough, is you can do the best possible for me to make it available to as many people as possible, and find ways and to adjust, and just be aware that if the Europeans and the North Americans are discussing issues, yeah, and this is not a criticism, it's just we all do this in our bubbles, yeah. It is a bubble. It is nothing else as a bubble, and there are other people outside the bubble. You need to try to get into the bubble. Yeah, that needs to be. Yeah, you just are not allowed to stop in your discussion and think it's a be and end all what you're discussing. That's my only comment on that.
Yeah, I mean, I do, but on the other hand, a medium-sized arbitration where everyone has to travel and spend a couple of weeks for an SME is also likely to be very disruptive and costly.
Yeah.
Interesting.
Yeah, they don't do that either. So the New Zealand SMEs don't do anything. They just negotiate and try not to have any disputes. Yeah, but I think I'm just mentioning that's. But if that's the starting point, if you want to include that and make it available, then just don't herald. I think my warning point is don't herald, online suddenly as the silver bullet. Yeah, you need to work on that to make it that.
I had one final question for our hosts as well. I mean, I do quite like online hearings, but I really don't like online teaching. So it's funny how these things are different. I don't know what all of you are very respected teachers.
I couldn't agree more. David. Couldn't agree more. It's not the real thing. It's a substitute.
I think exactly as Petra was mentioning, depending also on the situation that students have at home, and this is also true for our Vis Moot teams, that changes their learning experience enormously. And that's something we have to take into account. And it's exactly the same in justice. For big players, it might be just a good efficiency enhancing tool. For an SME, or think outside of commercial dispute resolution, think of family matters or think of labor matters. It can be extremely stressful to be home and thinking, oh, the judge will connect with me via video connection. What if my video connection is not good? That's something we cannot ignore.
Some people do not have a convenient place at home to do this kind of thing. And, it's true.
Yeah. I've seen a lot of bedrooms. Let me tell you that. And that's actually quite telling. I actually have taught online already years ago, so for me it was not so much an issue. What I quite liked is, we didn't have, we are the country where you can actually, as Petra and I discussed, we're having parties and we actually have in-class teaching. But I think again, it has catapulted us to do is to actually now think and actually look at the positive. And what I've done in one of my classes, I flipped the classroom. So I did record and gave it to the students. So it was basically online for 2 hours. And then I went 1 hour into the classroom and discussed with them what they had seen. And that worked, I have to say, fantastically. I never had a better class than that class. So the students who can actually deal really well with online have done fantastically well for us. We had a few students, that's what we have seen, as we had actually issues like was, I think, the self-management around online is really problematic for some students, not having to go to a lecture and that.
Yeah.
Undoubtedly, there are some potentials to tap into with both online teaching and online arbitration. And to be honest, when I heard this comment, well, it makes arbitration more expensive because people are prepare, it also makes it better. It's a better use of money than a hotel. On this note, Andre, if you agree, I would really like to thank Petra and David for their generosity, for their time. This has been a real treat for us and for all of the Vis Moot teams that will watch the video. We're really grateful for your time and for your insights.
Yes, well, thanks a lot again, David. Thanks a lot, Petra. That was really a wonderful occasion to exchange some thoughts and also seeing you again. And I see, Petra, you even have a postcard from Vienna behind you. So it's like, okay. So hopefully we will see each other in person soon, wherever that may be. And
I hope so.
Thank you so much for your time and effort. It was really an enormous pleasure and honor to have you. Thanks a lot.
Thank you for having me.
Thanks for inviting me. Yeah, it was really a real pleasure. Lovely to see everyone.